Have you ever gone through how the scales of justice find balance in the dynamic legal landscape of Nepal? Today, we delve into two distinct legal perspectives that steer this balance: legal formalism and legal pragmatism. In the heart of the Himalayas, the legal system of Nepal is a fascinating interplay of these two approaches. Legal formalism, or the rule-book approach, epitomizes a strict adherence to legal rules and principles. It is akin to a meticulous chef following a recipe to the letter, focusing on the literal language of laws and statutes. The role of judicial discretion or broader policy considerations often takes a back seat. However, as with any recipe, cultural, historical, and institutional factors can influence the outcome. On the other hand, legal pragmatism paints a more flexible picture. It's the improvisational chef, adapting the recipe to the ingredients at hand. Pragmatism places emphasis on adapting the law to the practical needs of society, considering the context and consequences of legal decisions. It's about achieving practical and just outcomes rather than rigidly sticking to the recipe. However, critics of these approaches have their reservations. Legal formalism, they argue, can be rigid, struggle to adapt to changing contexts, and underestimate the role of judicial discretion. It may prioritize the letter of the law over real-world consequences, potentially leading to unjust outcomes, and might not adequately consider principles of equity and fairness. Legal pragmatism, while flexible, is not without its critics. They argue that it can be overly subjective, reliant on a judge's personal values and opinions. This subjectivity might sacrifice legal certainty, leading to unpredictable and arbitrary legal outcomes. It could enable judicial activism, where decisions align more with personal policy preferences than established legal principles, potentially undermining the rule of law. Despite these criticisms, it's important to remember that these approaches are not mutually exclusive. They offer different lenses through which to view and interpret the law, and their interplay shapes the legal landscape of Nepal. In summary, legal formalism and pragmatism in Nepal offer contrasting perspectives on legal interpretation and decision-making. Formalism emphasizes strict adherence to legal rules and principles, often downplaying the role of judicial discretion or broader policy considerations. Pragmatism, however, emphasizes adapting the law to the practical needs of society, considering the context and consequences of legal decisions. The interplay between these approaches shapes the dynamic legal landscape of Nepal, influenced by a balance of cultural, historical, and institutional factors. Remember, as with any legal approach, there are pros and cons, and the best outcomes often involve a balance between the two. The scales of justice continue to find balance in the dynamic legal landscape of Nepal, guided by the interplay of legal formalism and pragmatism. Scene script, voiceover. Now let's delve into why both formalism and pragmatism are relevant in our legal systems. The choice between them often depends on the legal system itself, the nature of the case at hand, and the societal values that underpin the law. Formalism brings much-needed legal certainty and stability, and it respects the legislative intent. It provides a clear framework within which legal disputes can be resolved without bias or ambiguity. Pragmatism, on the other hand, offers adaptability, justice, and equity. It allows the law to be flexible and responsive to societal changes and unique circumstances that may not have been foreseen by the legislators. In practice, however, a legal system cannot function effectively with a purely formalistic or purely pragmatic approach. The context matters, and judicial discretion plays a crucial role. Legal systems often navigate between these approaches, recognizing that striking the right balance allows for the application of established legal principles while considering the practical implications and justice in individual cases. So, in essence, the interplay of formalism and pragmatism is not just a theoretical debate, it is a practical necessity in the quest for justice.